मिल गया। तो 360 है, और बना मिल गया। तो 360 है। Yes, helping. Yes, helping. Yes. Yes. Because they have crossed the age bar. These petitions, there are four petitions. The age bar. But there are totally 10 people like that. These petitions, there are four petitioners. But there are totally 10 people like that. Aspect we leave to the high. All 11 have crossed the age bar. All 11 have crossed the age bar. What about seniority? You're saying you'll forgo everything. What about fresh appointments? You're saying you'll forgo everything. Fresh appointments.
Ms. Haripriya, there are also elements. It's not just you get into the job. You have to undergo that 1 year training. There are also elements. That's one of the things. It's not just you get into the job. All across the board, in the entire judicial system of Kerala. That's one of the things. The prejudice that you are talking about, they will continue to suffer this prejudice of Kerala. Junior to their batchmates. The prejudice that you are talking about, they will continue to suffer this prejudice. Although they might be desperate enough to say that, please give us even now. Through their service career. And you see, that's also something. Lose, although they might be desperate enough to say that, please give us even now. Also opportunities by growing older. As you lose opportunity by growing older, you gain also opportunities by growing older. I'm just stopping there. That's Article 1416, right? How do you also deprive the people who have qualified in the last 6 years of the vacancies which actually they should be competing for? People who have qualified in the last 6 years of the vacancies which actually they should be competing for. You are usurping their. It's a cascading thing. It's not just one thing. You see. See again, it's a cascading thing. It's not just one thing. You see.
The rules today, what do they provide? The
35%.
35% today, what do they provide? When did that amendment come up?
2017.
17, that
35%.
amendment came. 35% has been provided. When did that amendment come up?
2017.
17, that amendment. Is that, by the way, is that that amendment of 2017 somewhere in the compilation, just for the sake of? Is that, by the way, is that that amendment of 2017 somewhere in the compilation, just for the sake of? Yeah, in case you have it, I mean, it's nothing turns on it.
You all submitted detailed submission on the main issue before the constitutional bench as well.
In case you have it, I mean, it's nothing turns on it.
The final submitted detailed submission on the main issue before the constitutional
But we
bench as
don't
well.
need to go into the broader
Lordship
issue
will just consider it while passing the
of,
final
changing the
judgment
rules of
retake.
game here at all.
Our submissions
Not in
are on
Kerala
record.
case,
But we don't need to
it
go
would
into the
apply
broader
to
issue
Tej
of,
Prakash as
other
well.
cases, of course, the rules of game
other
here at
cases,
all.
if you
Not
people
in
are here,
Kerala
you'd like
case,
to assist
but
us, you're most
it would
welcome.
apply
Yes,
to
It is
Tej
there in our
Prakash as
submissions,
well.
of course, in fact, in the other case, if you people are here, you'd like to assist
Yes,
us, you're most welcome to
Yes, Your
assist
Lordship.
us.
So it is
But
there in our submission. So as and when the necessity
Kerala
arises.
case, it doesn't arise strictly speaking.
Yes, Your Lordship.
Which were given to these, in that batch, in the 2017. Was it made subject to the outcome of this petition? That batch.
Even today,
in the
this appointment letters
2017.
all said subject to.
Was
result
it
of
made
this
subject to the outcome of
every
this
single
petition?
appointment made, even today,
after that,
even
some
this
of those
appointment
letters
letters all
carried
said
forward.
subject to result of
Every
this
single
appointment made, every single appointment made clearly even after that, because some of those vacancies carried forward.
Are all of them
Every single
parties?
appointment made,
Lord,
three of them, because others won't be affected.
affected.
We said only three
Are
will
all
be
of them
affected, so
parties?
only three are here. My Lord, three of them, because others won't be affected. We said only three will be affected, so only three are here.
Documents. New
Who
rule
is appearing for those three candidates? The three candidates respond
New
numbers
release
9,
documents.
11 and
New
12. Who
release
is appearing
document
for
number-
those three candidates? The three candidates respond numbers 9, 11 and 12. Your appointments were made subject to the result of this writ petition, right? What do you have to say? Your appointments were made subject to the result of this writ petition, right?
Yes. Responsive. That's easy, yes. Responsive. Say that.
Select list. Sorry, Lord. There was no stay of operation of the select list. Select list. Lord, equity, fairness and Lord, there was no justice stay of operation of the select list. Be allowed to. Lord, equity, fairness and Lord, I am not holding that demands that Lord, they should be allowed to continue. I am not holding that the petitioner should not be given range.
Mr. Naidu?
It is not our, sorry.
Please unmute.
Ms. Naidu, please unmute yourself.
And,
Mr. Naidu? Yes.
It is
Yes,
not our.
now I
Please
can
unmute.
Ms. Naidu, please unmute yourself.
No, they have.
Yes.
Those who have already been in minutes, the candidates that have been selected having discharged judicial functions blemishlessly. Those who have already been in they may not be candidates that have been selected having discharged
Now, what
judicial
about these
functions blemishlessly. All these yes, they may not be upset.
The left out candidates. Now, what about these candidates, who are before us?
Left out.
Yes.
The left out candidates.
What is
11
to be
of them,
done
about
right?
them.
Yes.
What is to be done about
It's a
them?
decision. I may be pardoned for repeating that we have taken consciously. It's a decision. The full bench has maybe pardoned has unanimously accepted that we have taken consciously decision. The full bench has full court has unanimously accepted that administration, judicial administration. In the interest of not the efficacy of the administration, judicial administration. So such a decision could it be upset? We have not played favorites all these years later. And no mala fides. So such a decision could it be upset down the line all these years later?
Can I take 1 minute before I dictate? Just 1 minute. Can I take three things? Just one, like a lordship rightly seen, the rule, the scheme, The notification. One, like a nowhere prescribes minimum marks for that. Is key. Why I'm saying after the notification 6th March, nowhere prescribes minimum marks. We have been vigilant again. We filed the writ after the selection order was passed in November 17. 5th April, we filed the writ. I'm just saying we have been vigilant again. We filed the selection list. The 5th order was passed in November 17. Exactly 1 month.
5th April was the date of the new
6th
notification.
March is the selection list.
Amended
5th April. With exactly
What
1
is the
month.
date of
after
the
was the date of the new
Document number
notification.
17.
Yes, madam.
Amended
Might
notification.
Approves the writ petition.
What
is the date of the notification?
Document number 17.
Petition.
In my
Approves the writ petition.
First document number 17, yes, I mean, September document number 17, back letters numbers 104.
17 is the amended.
Yes,
April,
amended.
petition
Document
is
number
filed.
17,
14 November
back
is a
letters
reference
numbers
order.
104.
Now thereafter, we tried mentioning because of the petition is backlog, etc. 14 November is a reference order. Now if today the lordship finds that the minimum prescribing cutoff marks is not permissible. Now if today a lordship finds that I'm not saying I don't want them to go cutoff marks is ideally not permissible. Situation for us is we are some relief will be granted to that. I'm not saying I don't want them to go. Some relief for us. Ideally, the lordship situation for us that we are there. They are there. The minimum I'm saying fixation of minimum cutoff marks is wrong. Otherwise, if a lordship today relief is granted to us, the minimum fixation of minimum cutoff marks is wrong. And no relief is granted to us, my lord. So I don't know what can my lordship may kindly with your last experience do something by which we also benefit from that. I understand, but I don't know what can my lordship may kindly with your last experience do something by which we also protect. I understand.
The reality is that actually 6 years our
The full court prescribes saying no cutoff. Administrative committee says, oh, that they would not have meant it. The full court prescribes saying no cutoff. Administrative committee says, oh, that relief they would not have meant it. Done for us. That's all I'm saying. Only requesting is not that at least relief something may be done for us.
There are a lot of administrative posts on the relief as well as tribunals also. Apart from this judicial post, my lords, there are a lot of administrative posts as well as they can be tribunals also. Now, so many places claims tribunal.
Expending.
They can be and
All right,
so
I'm
many
sorry.
places, my lords,
I may submit, my lords. I may submit to make ironical. But they say that I may submit relief will be granted. I may submit, in fact, principle could be laid down. They say that history bears be granted. Every line of judgment beginning from principle could be laid down. Principles have been laid down, but not the relief line of judgment beginning from Keshwan. Because by then it was not possible. Principles have been laid down, but not the relief granted. Because by then it was not possible.
2017, as I look at that. A bench of 2 judges of this court, November 2017, referred a bench of 2 judges of this court, a batch of 4 petitions, referred a batch of 4 petitions, which invoked the jurisdiction of this court under Article 32 of the Constitution, which invoked the jurisdiction of this court under Article 32 of the Constitution. Shivanandan CT, the Constitution High Court of Kerala. In 2018 CT, 1 SCC versus High Court of Kerala. 2018, stop. 1 SCC 239. 11 petitioners, stop, are before this court. 11 petitioners are before this court, all of whom are candidates aspiring to be selected as aspiring to district judges be selected in the higher judicial service as district judges state of Kerala in the higher judicial service of the state of Kerala selection in pursuance of 2015. A selection of 2015. The in the state of Kerala, the Kerala state of Kerala, hired the judicial service Kerala Special Rules 1961. Hired judicial came into force. Special Rules 1961 on 11 July 1961 came into force. These rules have been 11 July 1961 under Articles 233 and these rules have been framed under Articles 233 and 309 of the Constitution. The rules provide for the three categories. Rules provide for the rules provide for the constitution of the service. Three categories. The rules provide for the constitution of the service. Three categories. Into colon bracket 1 super time scale district and sessions judges semicolon bracket 2 colon bracket 1 super time scale district and sessions judges semicolon bracket 2 district and sessions judges selection grade district and sessions judges including additional district judges 3 district and sessions judges. The dispute in the present case, additional district judges. The dispute in the present batch of cases pertains to the third category. The dispute in the present case, noted above. The dispute in the present batch of cases pertains to the third category. Rule noted above. Bracket C, Rule 2 provides for appointment to the third bracket C category. Provides for appointment to the third category. Rule 2C3 stipulates Rule that C3 25% of the posts in the category stipulates that shall be filled by direct 25% of the posts from the bar in the category into invert commas, shall be filled by direct recruitment on the basis of aggregate marks stroke grade commas obtained in a competitive on the examination basis of aggregate marks and viva voce stroke grade obtained in a competitive examination and viva voce conducted by the High Court. On 30 September 2015, on 30 a notification September 2015 was issued by the notification High Court of Kerala was issued by which by the High Court of Kerala applications were invited by which some qualified candidates applications were invited for appointment as district and sessions judges from qualified candidates in the Kerala State Higher Judicial Service for appointment as district and sessions judges by direct recruitment in the Kerala State Higher Judicial Service by direct recruitment from the bar. Clause paragraph 5 of the notification provides for the mode of selection. Paragraph 5 of the notification provides for the mode of selection. Paragraph 5 stipulates that the selection would be on the basis of a competitive examination. Stipulates that the selection would be on the basis of a competitive examination consisting of a written examination and a viva voce. The total marks assigned for the written examination were the total marks assigned for the written examination, 2 papers, each carrying a maximum of 150 marks. Comprising of 2 papers, each carrying a maximum of 150 marks. Candidates belonging to the OBC category. General candidates and candidates belonging to the OBC category and SC/ST candidates who secured 50%, 40% and SC aggregate minimum marks for both the papers together. 40% aggregate minimum marks for both the papers together qualified for the viva voce were to be declared as qualified for the viva voce prescribed for the viva voce were 50. Full stop. The maximum marks prescribed for the viva voce stipulates that, into invert commas, the merit list of successful candidates stipulates that, into invert commas, will be prepared on the basis the merit list of successful total marks obtained will be prepared on the basis and viva voce of the total marks obtained complete. In the written examination 73 and viva voce 501.5 into invert commas complete. ये आपको मिल जाएगा page 873 in 501.5. The notification किया ना बताया ना उसके पहले ये लिख लो आप notification after the rules of 1961 उसके पहले ये लिख लो आप were notified after the rules of 1961 the High Court of Kerala were notified had by notification dated 13 December 2012 High Court of Kerala had by notification dated 13 December 2012 for the examination prescribed page 26 the scheme for the examination. The scheme is notified by the High Court. The scheme is notified by the High Court contain the following stipulations. Colon, contain the following stipulations. Bracket 1. Colon. The Kerala Higher Judicial Service Examination will have a written examination for two papers. Kerala Higher Judicial Service Examination will have a written examination for two papers carrying 150 marks each, with a total of 350 marks carrying 50 marks, so assigned, semicolon, bracket 2, with a total of 350 marks, so assigned, semicolon, bracket 2. Separate minimum marks were not prescribed for each paper, while separate minimum marks were not prescribed for each paper, who secured at least 50%, general category candidates in the aggregate, who secured SC/ST candidates who secured at least 40% in the aggregate for both the papers together, and SC/ST candidates who secured at least 40% qualified for the aggregate for both the papers together would be qualified for the viva voce examination. The viva voce test, bracket 3, the viva voce test, into invert commas, in a thorough and scientific manner, to invert commas complete, into invert commas, for a period ranging between 25 to 30 minutes for each candidate complete. For a period ranging between 25 to 30 minutes into invert commas, there shall be no cutoff marks for the viva voce. Semicolon, bracket 4, into invert commas, there shall be no cutoff marks for the viva voce. Bracket 5. The merit list would be prepared on the basis of marks obtained both the merit examination would be prepared on the basis of marks obtained both in the written examination and the viva voce. Following the notification which was issued by the High Court on 30 September 2015, following the notification which was issued by the High Court on 30 September 2015, was conducted on 12 and 13 March 2016. The written test was conducted on 17 December 2016. The notification on 17 December 2016 regarding candidates who had qualified in the written test notification came to be published. Regarding candidates who had qualified in the written test, following this, between to be published. 16 January 2017 and 24 January 2017. Between 16 January 2017 and 24 January 2017 for all the qualified candidates was conducted. The viva voce for all the qualified candidates was conducted. Next. On 27 February 2017, next, on 27 February 2017, oral interviews after the viva voce was conducted, oral interviews after the viva voce was conducted. Administrative Committee of the High Court, the Administrative Committee resolution of the High Court passed a resolution decided to apply the same which it decided cutoff of marks to apply which was prescribed for the written examination. The same minimum cutoff of marks which was prescribed for the written examination as a qualifying criteria as an eligibility as a qualifying criteria. Let's stop. In coming to this conclusion, the administrative committee, in coming to this conclusion, was of the view the administrative committee appointments were being made to the higher judicial service. That since it was necessary were being made to the higher judicial service with the requisite it was necessary to select candidates and knowledge with the requisite which could be ensured personality by prescribing and knowledge a cutoff which could be ensured for the viva voce by prescribing in terms similar to the cutoff which is prescribed for the viva voce in terms similar to the cutoff which was prescribed for the written examination of the administrative committee was approved by the full court of the Administrative Court of Kerala was approved by the full court 6 March of the High Court of Kerala 2017 on 6 March 2017 while approving the while approving the decision of the Administrative Committee court was of the view the full court was of the view don't say that. Just leave it at 6 March 2017. Let's stop. Don't say that. Just leave it at 6 March 2017. Of the full court. Let's stop. The decision of the full court and the resultant promulgation of the list of successful candidates and the resultant promulgation of the list of successful candidates before the High Court of Kerala led to the institution, before this court of writ petition before the High Court of Kerala on 5 April 2017. Before this court under Article 32 of the Constitution on 5 April 2017. The candidates who are before this court are aggrieved by the facts who are before this court as a result of the application of the cutoff in the viva voce are aggrieved by the fact that as a result of the application of the cutoff in the viva voce though there have been the aggregate of marks selection, though in the aggregate of examination and the viva voce, in the written they would rank higher examination and the than many of the viva voce, who have been selected. They would rank higher than many of the candidates. The specific grievance selected was urged before this court when notice was issued. This specifically in relation to three respondents was urged before this court when notice was issued. Respondents 9, particularly 11, in relation to to 3 respondents. Respondents 9, 11. When the petition was taken up by a 2-judge bench of this court. When the petition November was taken up by a 2-judge bench of this court. A reference was made November 2017. Following. A reference was made to the Constitution bench. Reference following made to an earlier the larger bench. Reference made to the larger bench in Tej Prakash Pathak. In Tej Prakash Pathak. Citation of that 2013 4 SEC 540. You have the citation of that 2013 4 SEC. By making the reference to the Constitution bench in the above in the earlier decision. By making the reference to the Constitution bench, the principal issue in the above in the earlier decision, whether the principal issue It is open and been addressed. Whether, when a selection process is instituted, it is open in law to change the rules of the game. When a selection process is instituted, to change the rules of the game midstream. Good stop. In that context, in that context, was placed on an earlier decision. In case placed on versus state of earlier decision another. In case 2008 versus state of Andhra Pradesh another. 2008 SCC would stop. 5 1 the view which has been prima facie expressed. Don't say that. The view in Manjushri, the view which has been doubted on the ground. Don't say that. The view in Manjushri has been doubted on the ground. The principle which has been laid down in that earlier decision would appear to run contrary to an earlier decision in 1974 to 20. Stop. 1974 to 20. During the course of the hearing, we have heard arguments on behalf of the petitioners. During the course of the hearing, we have Mr. P.V. Dinesh heard arguments, learned counsel, on behalf of the petitioners, Mr. V. Dinesh, learned senior counsel, Ms. Haripriya, Mr. V. Chidambaresh, learned senior counsel, Basant. That's the four of you, right? Nobody else. Padmanabhan and Mr. Ragin Basant. That's the four of you, right? Nobody else. Next. In the view which we are inclined to take in the present case, it does not become necessary. In the view which we are inclined to take in the present case, broader constitutional issue, it does not become necessary to rule on which a reference has been made, broader constitutional issue in Tej Prasad Pathak, on which a reference has been made. Full stop. In Tej Prasad, the reason why we have come to this conclusion would be elaborated shortly hereafter. The reason why we have come to this conclusion principally elaborated shortly hereafter. The modalities which have been followed by the High Court of Kerala, for selection, modalities which have been followed by the High Court of Kerala have been assailed on 4 grounds. The course of the process, have been assailed on 4 grounds. In specifying, bracket 1, cut off for the viva voce. In specifying, the High Court has acted in a manner contrary for the viva voce. Rule 2, bracket C, the High Court has acted in a manner contrary of the Rule 2, bracket C, Kerala, bracket 3 of the Kerala State of Higher Judicial Service Special Rules 1961 of the Kerala State Higher Judicial Service Special Rules 1961 to brackets you say the scheme which was notified by the High Court on 13 December 2012. The scheme which was notified by the High Court on 13 December 2012. There shall be no cutoff for the purposes of the viva voce. That there shall be no cutoff. 3. For the purposes of the according to the scheme which was notified in 2012. 3. The only criteria for shortlisting according to the scheme which was notified in 2012. The only criteria for shortlisting of candidates, right? This is scheme. Yeah, that is according to the notification, the only criteria for the purpose of shortlisting candidates, according to the notification, would be the only criteria for the purpose of shortlisting by candidates at the bar would be the length of service to operate in a situation rendered by candidates. Number of candidates was found to be unusually large, which was to operate in a situation where the number of candidates was found to be unusually large. The decision of the decision of the and bracket 4 full court of the High Court, or the decision of the decision of the decision of prescribe a cutoff full court of the High Court or the decision of the full court was notified to prescribe a cutoff much after the viva voce was held, was notified, as a consequence of which, much after the viva voce was held, as a consequence of which, that such a requirement would be introduced at the inception of the process, had no notice that such a requirement would be introduced, at the inception of the process. Mr. Damashesha Naidu, Learned Senior Counsel, has appeared on behalf of the State of Kerala. Mr. Damashesha Kerala, Learned Senior Counsel, has appeared on behalf of the State of Kerala. Number 9, right, or 11. High Court of Kerala, 11. While Mr. Swain appears for respond number 11. 9, right, or 11. 11. Mr. Kailash Naik Pillai appears for respond number 11. Next. The 1961 rules clearly specify, that clearly specify that 25% of the aggregate posts which are to be filled in, of the aggregate posts by direct recruitment from the bar, which are to be filled in, would comprise by direct recruitment from the bar. The marks obtained would comprise of the list of candidates. The marks selected obtained on the basis would comprise of the obtained in the aggregate of the list of candidates selected in the written examination and the viva voce. On the basis of the marks obtained in the aggregate, would stop. These rules in the written examination and the viva voce, as already noted earlier, would stop. These rules have been framed in exercise of the power conferred by Articles 233 have been framed 309 of the Constitution. In exercise of the power conferred by Articles 233 and 309 of the Constitution. After the statutory rules were notified on 11 July 1961, statutory rules were notified, the High Court of Kerala on 11 July 1961 published the scheme of the High Court of Kerala for recruitment of published members of the bar to the scheme of the examination service for recruitment on 13 December 2012. Members of the bar to the Kerala Higher Judicial Service will stop on 13 December 2012. Scheme so notified will stop. The specifically provides scheme so notified that there shall be no cutoff marks. Specifically provides for the viva voce that there shall be no cutoff marks. Full stop. For the notification, which was issued by the High Court on 30 September 2000. The notification, which was issued by the High Court on 30 September 2000 for the conduct of the 15 ensuing examination, provided that the mode of selection ensuing examination would consist of, provided that the mode of selection papers, each carrying 150 marks, 2 written candidates, each carrying 150 marks, and OBC candidates from the general who secured a minimum of 50% marks, and OBC category who secured a minimum of 50% marks to 40% for SC/ST candidates, bracket, would qualify for the viva voce. 40% for SC/ST candidates, bracket, full stop, would qualify for the viva voce. It turns out that the aggregate of marks in the written examination and the viva voce would form the basis that the aggregate of marks in the drawing up examination and the viva voce would form the basis, full stop, of drawing up the merit list. In the above backdrop, it is evident that, full stop, when the process began, the process of selection, the above backdrop, it is evident that all candidates were clearly put on notice of the fact the process of selection commenced, that the merit list would be drawn up on the basis of the aggregate marks obtained in the written examination and viva voce. That the merit list would be drawn up on the basis of the aggregate marks obtained in the written examination and viva voce. That candidates with the prescribed minimum, candidates whose marks that were candidates with the prescribed at the prescribed minimum in the written examination marks were qualify for the viva voce at the prescribed minimum. In the written examination, there was no qualify for the viva voce. In respect to the marks to be obtained in the viva voce, there was no cutoff applicable while drawing up in respect to the marks to be obtained in the viva voce, while drawing up, the decision of the High Court in the aggregate to prescribe the decision of the High Court, a cutoff in the viva voce, was taken by the Administrative Committee, a cutoff in the viva voce, 7 February 2017, was taken by the Administrative Committee. The viva voce was conducted between 16 and 24 January 2017. After the viva voce was conducted between 16 and 24 January, the process which has been adopted by the High Court suffers from an element of the process which has been adopted by the High Court suffers from several infirmities. An element of being firstly, the decision of the High Court was contrary to firstly provisions of Rule 2C. The decision of the High Court was contrary to that the merit list will be drawn up on the basis of which stipulates obtained in the aggregate that the merit list will be drawn up on the basis of and the viva voce. The marks obtained in the aggregate in the written examination. Secondly, and the viva voce. The scheme which was notified by the High Court on 13 December 2012. The scheme which was notified by the High Court on 13 December 2012 marks that there would be no cut-off marks. That there would be no the viva voce marks. That there would be no cut-off marks. Thirdly, in respect of the viva voce, the notification of the High Court dated 30 September 2015. Thirdly, the notification of the High Court dated 30 September 2015 that the process of shortlisting which could be carried out would be only on the basis of the process of shortlisting which could be carried out of the members of the bar would be only on the basis should the number of candidates be unduly large of the members of the bar, and fourthly, should the number of candidates be unduly large. The decision to prescribe a cutoff for the viva voce. The decision to prescribe cutoff marks for the viva voce was taken much after the viva voce. Prescribe cutoff marks for the viva voce was taken much after the month of January 2000. The viva voce tests were conducted. In the month of January. For the above reasons, 2017. We have come to the conclusion. The broader constitutional issue which has been referred. For the above reasons, we have come to the conclusion. In Tej Prasad, the broader constitutional issue which has been referred would not merit in Tej Prasad on the facts of the present case. Would not merit clearly decision on the facts of the present case by the High Court. The decision which was taken by the High Court clearly was ultra vires rules 2 which was taken by the High Court. The decision which was taken by the High Court as it stands was ultra vires rules 2. As a matter of fact, during the course of the hearing, we have been apprised of the fact as it stands that the rules have been subsequently, as a matter of fact, amended during the course of the hearing. We have been apprised of the fact. So as the rules have been subsequently a cutoff amended 35% in the viva voce, which however was not the prevailing legal position. 35% marks when the present process in the viva voce, which however was initiated not the prevalent legal position on 30 September 2015. The present process of selection was undoubtedly initiated. The High Court may have been 2015. The High Court was undoubtedly. The High Court may have the Administrative Committee of the High Court. The High Court was decided to impose a cutoff. The Administrative Committee of the High Court examination decided to actuated by bona fide reason of the viva voce examination that candidates with the requisite personality by bona fide reason judicial office of ensuring that candidates with the requisite personality assume judicial office. Administrative Committee may have been, however laudable that such a change was required to be brought in. Approach of the substantive committee may have been, which came in much later. Such a change was required to be brought in above by a substantive amendment to the rules, which came in much later. This is not a case where above the rules or the scheme of the High Court was silent. This is not a case where the rules or the scheme of the High Court was silent. The well principle of law that where these statutory rules are silent principle of law, they can be supplemented in a manner consistent with the object and spirit of the rules. Are silent by an administrative order. They can be supplemented in a manner consistent with the object and spirit of the rules. The statutory rules and administrative order expressly provided. In the present case, the select list would be drawn up on the basis of the aggregate of marks obtained expressly provided written examination list would be drawn up on the basis of the aggregate of marks obtained in the. This was further elaborated. Written examination in the scheme of 2012, which prescribed that there would be further elaborated marks in the scheme of 2012, which prescribed that there would be no cutoff. Position is also reflected marks for the Viva. In the notification of the High Court dated 30 September 2015. Position is also reflected. This backdrop, in the notification of the High Court dated that the decision of the High Court suffered from its being backdrop, ultra-vires come to the conclusion that the decision of the High Court suffered from which were framed under Articles 233, ultra-vires 309. The besides being rules which were framed under Article 233 and 309. Besides being, having said this, manifest the question which now arises before the court is regard to the relief which can be granted. Having said this, to the question which now arises before the court is regard to the relief which can be granted. The final list of successful candidates was issued on 6 March 2017. The final list of successful candidates was issued candidates who have been selected 2017 would have now been working for and working as district judges. The candidates who have been selected a little over would have now been working for and working as district judges. In the meantime, for a little over 6 for about petitioners who are before the court have not functioned in the meantime in judicial office. All the petitioners who are before the court at this lapse of time in judicial office may be difficult to direct. Either the unseating at this lapse of time, the candidates who have it may be difficult their duties to direct. Either the unseating them at this stage, the candidates who have would be contrary to public interest, since they had gained experience. Unseating them at this stage, judicial officers in the meantime would be contrary to public interest. While they had the grievance of the petitioners as judicial officers in the meantime. If the aggregate of marks in the written examination and viva voce were taken into account, is that if the aggregate of marks in the written examination and viva voce were taken into account, who are respondents to these proceedings, they would rank higher. Equally, it cannot be lost sight equally, who are respondents to these proceedings. You cannot lose sight of the fact, equally, it cannot be lost sight selected candidates equally, are otherwise qualified for judicial office that have been working selected candidates over a length of time are otherwise qualified for judicial office would have been working being over a length of time, result in a situation where the higher judiciary will lose the services would, besides being duly qualified candidates who have gained experience, in a situation where the higher judiciary will lose the services of duly qualified candidates who have gained experience over the last 6 years. For these reasons, we have come to the conclusion that it would not be possible to direct the induction. For these reasons, we have come to the conclusion that it would not be possible at the present stage direct. Many of the petitioners would have since joined the bar service at the present stage. Would be in active practice. Many of the petitioners, it needs to be clarified, would have since joined the bar. There would be in active practice. Having failed to it needs to be clarified. In selection that to the higher judicial service, having failed to which gain selection was initiated on 30 September 2015. In the process, not a reflection either on their was initiated or on 30 September 2015 and shall not come in the way is not a reflection of their either on their merits or ability for any other office and shall not come in the way or otherwise of their future being considered for any other office subject to the official or otherwise in the view which we have taken in the above terms, we have not considered it necessary to answer the view which we have taken in the above terms, of constitutional. We have not considered it necessary to answer the referred to the constitution bench of constitutional the broader question which has been kept open. Referred to the constitution bench, to the constitution bench, The petition, the question is kept open. Besides, the question has been bench squarely raised. The petition in certain other cases, which form besides part of the question has been squarely raised, in which arguments in certain other cases, which form part of the present batch of cases, the petition in which arguments are being heard by the constitution bench. Full stop.
Let's say
The
one
petition
small
is
correction by
accordingly
Yes,
disposed of.
decision of the High Court on the administrative side, my Lord. Your Worship has said that. Decision of the High Court. One small
And
correction
the
by Lord.
administrative.
Yes,
side.
decision of
I'll
the High Court
correct
on
me.
the administrative side.
So these
Lord,
five
Your Worship
matters
has
are
said
over, right?
that.
Now,
Decision of
four
the High
matters.
Court.
Five,
On
and
the
the
administrative
0.5,
side.
0.6, 0.7, and 0.8. So these five matters are over, right? Now, four matters. Five. Now we take up Rajasthan, 0.6, 0.7, and 0.8.
Deeply.
Four matters. Now we take up Rajasthan, right?
Deeply.
Lordship, 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 Lordship.
वो रेफरेंस भी हो गया वो रेफरेंस भी हो गया
Lordship, may I Lordship, may I request, Lordship, that I may be taken in the last, as I had requested that these are the clerical staff, Lordship, that I may be taken in the
Now,
last.
this is Tej Prakash Pathak, no? That's the lead matter.
That's the lead matter, right?
So what we could do now is, now this is Tej Prakash Pathak, no? That's the lead matter.
That's the lead matter, right?
We had said that we will take up. So what we could do now is, we will take up, this is a lead matter. We had said that we will take up Rajasthan. You don't want to take up, we'll start with Rajasthan, this is a lead matter.
So I may be in the last and then I can point out few things which are different from them. So I may be easier last and then I can point out few things
It's straight away arise.
which are different from them. And it
Mr.
will be
Main reference order.
main reference order, so Lordship, what
It's
I'm
straight
saying-
away arise.
So that's the reference order.
Yes, it's a main reference order.
Main reference order, so Lordship, what I'm saying that in the last Lordship.
Which one should we take up? Who's now ready to the hill? Tell us.
Lordship.
Mr. Mukherjee, where
in
are
the
you?
last Lordship.
Which one should we take up? Who's now ready to the hill?
You're for
Tell
the
us.
petitioners in Manipur.
I'm
Mr.
there,
Mukherjee,
but
where are
You are
you?
in Manipur.
It arises in your case also, or are you saying
You're
that
for the
it won't
petitioners
arise?
in Manipur.
I'm there, Manipur.
And you are in Manipur.
No,
It
no,
arises in
it's
your case
completely
also, or
different.
are you saying that it won't arise?
It's completely different. No, it's completely
Okay,
different.
you are contesting that.
It's completely different.
That is Salam Samarjit Singh versus High Court of Manipur,
Only one.
501.4.
Refer to the PDF.
That is Salam Samarjit Singh versus High Court of Manipur,
Learned it the hard way.
501.4. It's so nice, it's so good that everybody is also on the same. I'm happy the registry is now circulating these files to all the
It's
lawyers.
so nice,
It's so good that everybody is also on the same. I'm happy the registry is now circulating these files to all the lawyers, and that's very important.
You want us to take the paper book?
Take your lordship, the PDF paper book, Manas? May I, the written submissions which you filed, straight, that your lordship will find that page, PDF page. The written submissions which we have filed. 460. That your lordship will find that page, PDF page 460.
Sorry. 480, I'm so sorry, 480. 460 is nice.
Just one second.
480, sorry. 480, I'm so sorry, 480. 460 is nice.
Just one second.
480.
हाई कोर्ट को नहीं बताया कि आप जीरो से नहीं है 5 सुप्रीम कोर्ट के मोटे मोटे हाई कोर्ट को नहीं बताया कि आप जीरो से नहीं है 5 सुप्रीम कोर्ट के मोटे मोटे जज बैठे वहां पर ये फाइल्ड
इसके पास है सिमिलर इसके पास है सिमिलर
Page 480, Manas.
Page 0.
Yes. Page 480. List of dates.
Page 0.
Broadly, large hinges on it.
So we'll quickly run through the list of dates. Good always to.
That'll be easier, broadly, large hinges on it.
That's the table, right? Quickly run through the list of dates. Good always.
So that'll be easier. List of dates to start, Manas, with the
That's
date and pages.
the table, right? Brief
That's
480 you said.
480.
480.
That the list of dates to start, Manas, with the
date and pages.
Starts at 482 PDF.
480 you said.
480 and 482.
This one.
It starts at 482 PDF.
So 2005 losses will find are the recruitment rules under 234.309. So 2005 losses will find are the recruitment rules under 234.309 based on the Justice Shetty recommendations. And this was after the Rule 7 is what is relevant for us, Mala, based on the Justice Shetty recommendations. Rule 7 is what is relevant for us, Mala, the relevant provisions.
Two 2005. Now we are concerned with Rule 7.
But no cutoff. Yes, Mala. So you can see the relevant provisions, Rule 7.
Now we are concerned with
Method
Rule
of
7.
recruitment, but no cutoff. Qualification, reservations, we can see the relevant provisions, Rule 7. To the MDS schools, method of competitive examination. Qualification, reservations, written examination of 3 papers of 100 marks each. MDS schools, competitive examination, 50 marks. Limited departmental examination, written examination of 3 papers of 100 marks each. Interview, viva voce, 50 marks. There's no cutoff.
These chapters of papers now we must have. Proposing that, now whoever has papers should be directed to make a contribution to the Supreme Court Bar Association Welfare Fund. Papers
We're seeing
should be
papers on the
directed to
table.
make a contribution to the Supreme Court Bar
I was just
Association
pleading
Welfare
with the
Fund.
Chief Justice for an exemption
We're
for
seeing
the
papers on
judges.
the table.
I was just
It was
pleading with the
rejected.
Chief Justice for an
Rejected.
exemption
It was
for the
rejected.
judges.
In fact, I make it a point not
It
to
was
take
rejected.
any paperbacks from
Rejected.
stores, man.
It was rejected.
I tell you, your next generation will not get it. I make it a point not to take any paperbacks from stores. I make it a point not to take any paperbacks or even receipts. I said, please put it on WhatsApp and send them to stores. I make it a point not to take any paperbacks or even receipts. I said, please put it on WhatsApp and send the bill to me. We got the PDF only yesterday. Downloaded. I got the PDF only yesterday, so I converted it fast. No, this is because we got the PDF only yesterday, Manoj. I got the PDF only yesterday, so I converted it fast.
I've seen on iPad, I've seen
We
it.
have decided code 1 to 5 will have the
We've seen it.
iPad.
No, but seriously, because we must now
We have
move to
decided
this,
code 1 to 5 will have
Once you
the
completely shift, you know
iPad. Yes,
how,
but
how
seriously,
easy and
because
how
we
easy
must
it
now
is.
move
they are
to
very
this,
adept at it. They do it very
Once
fast.
you
They are still
completely
learning.
shift, you'll know how.
Yes,
how easy
but it
and
keeps
how
on
easy
when I
it
see her,
is.
I am very adept at it. They do it very fast. Where's the iPad? They are still learning. She scolds me. But it keeps on when I see her, I hide my papers. She says, where's the iPad? Yes. She scolds me. So I told her I'm still learning. Yes, Rule 7. Now,
It's
so can
always
we
a
see clause
process.
1? Yes, a bit
But
below
hats
that.
off to my brothers, huh? I mean,
Okay,
everybody
Rule
has
7.
really been so cooperative.
Rule
Everybody is sort of very
Now, so can we see
eagerly
clause
doing
1?
it.
A bit
But
below
hats
that.
off to my brothers.
it's a new
I mean,
normal,
everybody has
actually.
really been
It's a
so
matter of getting
cooperative.
used to it.
Everybody is sort of
Delhi
very
High Court, I
eagerly
think almost
doing
all
it. And
judges are trained.
for us, it's a new normal, actually.
It's a matter of getting used to it. Delhi
Yes.
High Court, I think almost all. So Schedule B says, Malad, so we'll kindly have clause 1. Competitive examination, limited departmental
Yes.
examination, written examination, 3 papers, 100 marks each. Kindly have clause 1. Interview of Viva, 50 marks, no limited departmental examination. The cutoff comes in the next general 100 marks each. Interview of Viva, 50 marks, no more marks or corresponding. The cutoff comes in the next general instructions. Shall be eligible for Viva examination, provided that the SC/ST candidate, I am one of those, shall be eligible for Viva examination or corresponding grade in the written examination candidate shall be eligible for Viva examination. Who obtain 50% or more marks or corresponding grade in the written examination shall be eligible for Viva candidate who was eligible in the examination. 17 candidates I got part in this examination. Plus, I was the only candidate who was eligible. The advertisement Lodge in the examination. There are different grades. 17 candidates took part in this examination held in 2013. Lodge will kindly come. The advertisement Lodge will find there are different grades. We are not concerned with the grades. I need to show one clause in the first. Lodge will kindly come
Clause
to
2 is
page
important.
running
Selection of
PDF page
candidates shall be made on the basis of the
483. I need
cumulative
to show
grade
one clause in
values
the
obtained in the
first
written
block.
exam. Clause 2 is important. Selection of
And then my
candidates
Lord
shall
will
be
kindly
made on the
see the
basis of the
last
cumulative
clause
grade
3.
value
That's it.
obtained in the
I
written
didn't want
exam.
to interrupt. Only one thing, my lord, here the
And
rules.
then my Lord will kindly
My
see
lord,
the
read
last
mode of
clause
evaluation
3.
of performance and grading written in Viva shall be as
Only one
follows.
thing, my lord, here the rules.
70 so and
My
so
lord,
below
read mode of
40%
evaluation
evaluation
of
of performance and grading
No,
written
no,
in
that's
Viva
not
shall
just
be
a
as
minute.
follows.
No,
70 so and so
it's only
below
a grade.
40%
Let me
fail.
complete. You will have your chance.
No,
No, that's not
just
just
a minute, just a
fail.
minute.
It's a wrong
483.
interpretation. It's only a grade. This is what High Court should not do. Let me complete. You will have your chance. The High Court. There's nothing known as wrong interpretation. This is what High Court should not do. He's appearing for the High Court. There's nothing known as fail. It's only a grading given here. Where does the grading say it is fail? Or should we kindly see the grading? There's nothing known as fail. It's only a grading given here. I'm still where does the grading say it is fail? Or should
But
we
the
kindly see
grade
the
value is
grading?
0 basically.
The percentage
Below
has not yet come to
40%
the
you get
grading.
0.
I'm still in page 480. Now, what we
But
kindly
the
see.
grade value is 0
The
basically.
first block
For
relevant
below
provisions,
40%
clause
you get
3.
0.
Whatever clause 3. Now, what we kindly see, the first block relevant provisions. So 2 says selection after selection of candidates was based on the cumulative, which your Lordship just read.
Clause 3.
So 2 says selection after selection of candidates. This is what the High Court is relying on, which your Lordship just read. So all necessary
Clause
steps
3
not
is all
provided for
necessary
in these
steps.
rules. Lordship will note the word High Court is relying on. For recruitment under these rules shall be decided by the not provided for in these rules. All necessary steps. Note the word rules. Administrative. For recruitment under these rules shall be decided by the recruiting authority. So all necessary steps. Those are administrative
rules
steps.
are under Article 233.
Now,
Or
these rules which have been
234
framed
by the
309.
Manipur Judicial the 2005 rules are under Article 233 or
234 309.
309.
Then the grading is given at the next block at page 483.
Right.
So 70% grade grading is given at the next B plus at page 483. C, F.
Right.
So F 70% grade O, A plus, A, B plus, the grade value is 0. C, F. So you don't get a step up because in any case F is where you get below 40% is 0. The grade value is 0. So you don't get a step up because in any case for general candidates, 50 for SC. For the written examination.
But it said written examination and Viva OC exam.
60 for general candidates, 50 for the cumulative SC. I'm one SC. But for
It
Viva I
said
showed
written
50 marks but no
and Viva
cutoff.
OC exam.
That's an accepted position. So the cumulative grade.
And
But for Viva I showed 50 marks but no cutoff. That's an accepted advertisement of 15/5/2013. At that date, there was no cutoff. Then comes the advertisement of 5 applicant direct recruitment to one vacant unreserved post of district judge entry level. So there was applicant direct recruitment to one vacant unreserved post of district judge entry 2013. The written examinations were held. 17 appeared at the examination. The list is at page 122 PDF. The written examinations were held. 17 appeared at the examination. The list is at page 122 PDF. And there was a notification saying that none had qualified. Lodge will note this. 17/10/2013. And there was a notification saying that none had qualified. Lodge will note this. 17/10/2013. I did a RTI. It said none had qualified. And on 29/1/2014 found that I had 52.8% marks. Therefore, I 29/1/2014 found that I had 52.8% marks. Then I asked for a review. Therefore, I stood qualified.
When were the results declared?
Yes, Malas, the results are 17/10/2013. Then I asked for a review. That's at page 122.
When were the results declared?
Yes, Malas, the results are 17/10/2013.
That's the date of the result itself.
That's at page 122.
Okay,
So 4/2/2014, I asked for a review of this rejection of even my candidature. Then the High Court 7/2014 asked for a review of this rejection of even my candidature, saying that I had in fact qualified. Then the High Court 7/2014 issues a corrigendum, saying that I had in fact qualified, that I was the sole successful candidate. Then, my lords, before the Viva could be held, without any intimation to me, before the Viva could be held, a full court resolution was passed on the 12th of January 2015. Without any intimation to me, a full court resolution was passed. And this, my lords, makes a little interesting reading. If I may read this document once, my lords. It was specific to makes a little interesting reading. If I may read that PDF, Lodge will find at page 147. It was specific to me in the full court resolution at page 147. And that PDF, Lodge will find at page 147. This document is important in the full court resolution at page 147 PDF. There is a minutes of the full court held on 12/1/2015 at page 147 PDF. There's the minutes of the full court held on 12/1/2015 at page 147 PDF. And this full court resolution is specific by taking my name. And this full court resolution is almost the same as the P. Venugopal dietary aims. Taking my name. Your Lordship struck down that. It's almost the same as you cannot have a single specific dietary aim of one person. Whether your Lordship struck down that act saying that you cannot have a single specific to the High Court instead of one person. Can you see the resolution? So that becomes considering all the relevant provisions of Manipur to the High Court. Can you see the resolution? Considering all the relevant provisions of Manipur judicial. Malad, this is, let's have a look at the resolution at page 147.
12/1/2015.
Malad, this is, let's have a look at the resolution. 12/1/2015. Considering all the relevant provisions of Manipur Judicial Service. Yes. Shri Salam Samarjit Singh, who secured more than minimum all the relevant provisions of Manipur Judicial Service, qualified for interview. And he Samarjit Singh, who secured more than minimum qualifying marks for interview. Is qualified for interview. Question as to what percentage called for minimum qualifying marks of qualifying marks for interview is discussed. The question as to what percentage of the minimum qualifying marks of passing interview rules were taken into consideration, and they rely on the provisions of sub-rule 3 of all necessary steps judicial not provided for in this rules for consideration, and they rely on the clause 3 which I read, Manoj. All necessary steps evaluating the not provided for in these rules for in the written and viva voce shall be as specified below. The board of evaluating the performance of grading examination of judicial in the written and viva voce shall be as specified below. Then evaluating below the table, competitive examination of judicial selection after considering the power conferred on the recruitment authority in the above state below the table percentage of marks with grade value. The full court given above the power resolved that no one shall be declared passed and selected for appointment unless he scores given a minimum 40%. Resolved that no one shall be declared passed and selected for appointment unless he scores minimum 40% from the interview by Babose. The interview is almost like an executive instruction by using the so-called enabling power. The interview this submission is not a power by using the so-called enabling power, which in my respect says that 40% not a power. So Lordship has really amends the rule cumulative of by does not and says that 40% now. So this happens. Then the viva cumulative of by does not prescribe any cutoff marks. 2015, 1 year after then the viva happens in the first stage, which is 7/2/2015. I showed the letter. 1 year after my selection I am the sole candidate. First stage. They waited for 1 year. 7/2/2015. Held the full court. I showed the letter. And designedly said that there is a cutoff of 40%. They waited for 1 year and held the full court. The viva was designedly said that and I a cutoff of 40%. And 18.8%. The viva was held marks, and I apparently got 18.8% out of 50 marks. And therefore, that cutoff of 40% is not met by me by 1.2% out of 50. And therefore, that cutoff of 40% is not met by me by 1.2% out of 50. So the cutoff would be 20.
How much you said?
18.8% out of 50. So the cutoff would be 20.
Unlike the
40%
previous case which we decided Kerala,
yes.
The viva cutoff was decided here before the viva was actually decided Kerala.
Yes.
The viva cutoff was decided here before the viva was actually
informed about this. I had no knowledge of this cutoff, but there was a 1 year lag time. Right. Had I knowledge, I don't know what I was not informed about this. But I had no knowledge of that stage.
It was not as if the viva was held
and
thereafter
what I could have done. But I could still challenge it at that stage. The selection process was
on. The viva was held and thereafter they... Therefore, that issue of midstream changing
rules the selection process was on. And then this lag time of 1 year also.
Therefore, that issue of midstream changing rules
they said none had qualified.
Yes. So and then this lag time of 1 year also.
To that.
They kept
so
it
this
pending.
Process also. Otherwise, you are not even in the frame. So they now because give a corrigendum to that. So this process also. Otherwise, you are not even in the viva. But in the viva, you don't corrigendum. You come in the bench.
I come in the bench. As a lower and the rules now stand amended in 2016.
But in the viva, you don't.
They actually formally amend the rules in 2016. And the rules now stand amended in 2016. They actually formally amend the rules in 2016. Wait, Baba, if you keep on it. 9/3/2016 is a formal amendment to the rule, man. 9/3/2016 is a formal amendment to the rule, man. Judgment Hall. Judgment Hall. So Lordship will find that amended rule at page 285 PDF. 9/3/2016. The Lordship will find that amended rule at page almost 285 PDF. 285. 1 year, 1 month after the full court resolution. In between, so the Viva takes place. 285. 285. 1 year, 1 month after the full court resolution. I was told of the full court resolution after the Viva is over, when I was declared to be not successful. I was told of the full court resolution after the Viva is over, when I was declared to be not successful. So the cumulative would be A plus B, written examination plus Viva. So at the time of giving the exam, no cutoff marks A plus B, written examination plus Viva. And the rules come in at the time of giving the exam, no cutoff marks for Viva. Formally introducing this cutoff marks, my lord, at the end of the rules come in 9th of March 2016. General instruction. Formally introducing this cutoff marks, my lord, at the end of
Thereafter,
at page 287. There was a general instruction.
both of them differed.
They differed. Then
Thereafter, this is what.
thereafter, so there was a
Both they differed,
Yes.
both of them differed.
They differed.
When you filed the writ petition here, did you get an interim order?
no, we got an interim order.
No, both
The
of them
next
differed.
election, which was
And first of all,
scheduled for
when you filed
17.
the writ
It
petition,
was
post aside, get an
Yes,
interim
they
order.
said no. We got
So
an
that-
interim
so
order.
there was an
The
interim
next
order
election,
which
which
says
was
that
scheduled
direction
for
to keep
17.
postponed post aside.
Yes, they said interim order,
So
but we
that,
got
so
an
there
interim
was an
order.
interim
What
order
is
which
the
says
date
that
of that interim order?
direction to keep
No,
post
that's very
post aside.
2017. Because the interim order, but we got an interim order.
What is the date of that interim order?
It says 9/5/2017. It says that 4/5. If the selection process continues, the last selected candidate says that shall be intimated that his her selection is subject to the final result of this writ. The last selected candidate. The selection finally happened, I believe, in 2019 and 2021. The final result of this writ petition. The selection finally happened, I believe, in 2019 and 2021.
2017.
2017. And the selections happened in 2020. 17 was his interim order. So it says that the last selected
2017.
candidate shall be intimated. And the selections happened in 2021. So it says that the last selected candidate shall be intimated that his her selection is subject to the final result of this writ petition. So there are 4 selected.
they've deferred. They deferred on October 16.
Yes.
Right, they've deferred, and then they deferred on May 17, October 16.
Yes.
Right,
Yes. Now,
and then
because of the difference of opinion, may leave that judgment.
October 16.
Now, just because of the difference of opinion, may leave that judgment.
October 16.
इसको निकाल दो। That's fine. इसको निकाल दो। चलो चलो। क्या चला? चलो चलो। क्या चला? So, well, this the difference of opinion happened on 7th of October 2016. So, well, this the difference of opinion happened on 7th of October 2016. Arose for consideration. That's why I said the questions in my case will be slightly. May I hand over these three questions which, according to me, arose for
only
consideration.
difference
That's why I said
between yours and the
the
previous
questions in
one
my
is,
case will be slightly. May I hand over these three
after
questions
the
which,
written
according
test
to me,
was
arose
over in October
the only
2013,
difference between
yours and the previous one
filed
is
a writ
petition and all that.
Yes.
But after the written
court
test was
decision
over in
was in
October 12th of January
Yes.
2015,
That's
filed a writ petition
which
and all that.
interpreted
The rules and said
court
that
decision was in
the rule
12th of January
enables the
2015.
authority, the court
Which
to
interpreted the
adopt
rules and said
procedure.
that
Whatever
procedure. Yes.
the rule
So
enables
you say that rule won't
the
apply, it's
the
procedural
court
rule,
to
but then they refer
adopt
to that rule
procedure
whatever
and
procedure. Yes.
impose this
So
40%.
you say that rule won't apply, it's procedural.
And now that is
rule, but then
January
they
2015
refer
full
to
court.
that rule.
Yes.
And they
Impose
inform
this
you on
40%.
29th January. We just saw that. 29th
And now
January,
that is
they
January
inform you.
2015
That's
full
right.
court.
Within about few days thereafter.
They
No, they
inform
did
you on
not inform.
29th
After
January.
that, no, I'm
We
sorry,
saw that. 29th January.
They informed for the Viva voce.
Within
I
about
was not
2
informed
days
the full
thereafter.
court resolution ever.
About the Viva
No,
voce,
I'm sorry,
there will be a Viva voce.
They informed for the
That's
Viva
all.
voce.
They didn't tell you
I
about
was
the
not
Viva
informed the
voce.
full court resolution ever. I
About
came
the
to know
Viva
only through
voce,
RTA.
that there will be a
The Viva
Viva
voce
voce
was
was
conducted
thereafter.
thereafter.
They didn't tell you about this
Nothing.
50%.
Well, full court was, I came to know only through RTA.
Okay, anyway, the Viva voce was conducted thereafter in February 2015. Then the
12 to
decision was on
2015,
16
right?
February
Yes.
15 when they said that
Then
you are not
finally,
eligible for the reason that
I'm
you
almost
passed, you
not.
got
Then
only
the
18
decision
marks
was
out
on
of 16 February 15 when they said that you are not eligible for the reason that you got only 18 marks out of 40 marks.
18.8 out of
2015
18.5 out of 40.
then,
Yes.
which you challenged here again
It was
directly.
filed in 2015. I challenged that.
2015, Mr. Mukherjee, then.
Yes, it was filed in 2015. It was filed in 2015. It was filed in 2015.
Take a call.
What does it say for the Viva that all candidates who have obtained 60% or more marks for the Viva exam, all candidates who have obtained 60% or more marks and selection of candidates shall be made on the basis of cumulative grade value shall be eligible for Viva. Obtained in the selection of candidates shall be made on the basis of cumulative grade value.
So it is acknowledged that the cutoff was introduced only by the full court. Viva 50 marks. There was no cutoff. Accepted position is, so it is acknowledged that the cutoff was introduced only by the full court. There was no cutoff marks for Viva. A cumulative of that exam till that full court decision. There was no cutoff marks for Viva. Two sets of a cumulative of that exam where 60 plus the Viva. So if there are competing interests, you will obviously take the topmost candidates. Incidentally, I was the only candidate. So if there are competing interests, you get a margin or not, that's another aspect of the matter. Incidentally, I was the only candidate. Argue no indisputed right that I should get appointed. Margin or not, that's another aspect. We are only in the procedure today. My learned friend will argue no indisputed right that I should get appointed. Procedure as it existed. We are only in the procedure today. Did not broach of any Viva cutoff marks. That's the procedure as it existed. Did not broach of any Viva cutoff marks.
Why are you
That's
saying that the reference won't apply to you?
The reference, Manos, I'll tell you, Lordship, because the difference of opinion of this of the two learned judges here
apply to you?
was on three major issues. Reference, Manos,
was
I'll
on
tell
the
you, Lordship,
interpretation
because
of
the
the
difference of opinion
of the rule
of the two learned judges here. This is
So
was on three major issues.
was on the interpretation of the
On the interpretation
of the rules provision
is only
This is Bhanumanti,
procedural
how
and
you
not
felt
intended
about
to empower.
If we accept one of the
amendment
views
or addition
this provision
cutoff is only procedural
this
and
is
not
it
intended
says,
to empower.
that's the point of
amendment
distinction.
That's the
or
point of
addition of a
The
cutoff.
point is, and there are actually, may I just show the
which
three
says,
questions which we had
that's the
raised
point of
before the
distinction.
division
That's the
bench?
point of distinction.
And the point is, and there are actually, may I just show the three questions which we had raised before the division bench? And the two learned judges differed on all. He also goes to say there is malice in law. Held all three against us at para 45 of the judgment. All three in our favor. He also goes to say there is malice in law at para 45 of the judgment.
Ten years, what can we do for your client now?
I was telling you, I was going to answer the question that this was
10
wrong,
years,
but
what
I don't
can
know,
we do for
because
your client
today
now?
apparently I believe,
What's
I
your
was
client
telling
doing?
you, I was going to answer the question that this was wrong, but I don't know,
How old is he
because
now?
today apparently I believe,
What's your client doing?
because 2013 was the person 35 plus.
Now he can aspire
How
to
old
become
is
a
he
High
now?
Court judge.
He should be 46.
Is it really?
Because 2013 was the
Is
person
he
35
really
plus.
interested?
Now
Because
he can
right,
aspire to
that
become
is
a High
now,
Court judge.
joining now, then. Is it really?
At 46, we'll have no
Is it
career
Is it
ahead.
really
in the
interested?
career
Because
at
My
right,
thought
joining
is
now,
with
joining
respect
now,
to the smaller
then.
states, my lord.
At 46,
The
we'll have no
progression
career
is
ahead
faster.
in the
No
judiciary.
career at all.
Than
My
in
thought
these
is
larger
with
states.
respect to
No,
the smaller
not always.
states,
I'll tell you why. The vacancies are fewer
progression
also.
is faster than in
This
these
was only one
larger
single
states.
advertisement,
No,
single
not
post
always. I'll
advertisement.
tell you why. The vacancies
Singapore,
are
that's
fewer
what-
also.
Therefore, vacancies, as the Chief Justice. This was only
Later
one
on it
single
happened,
advertisement, single
four
post
came
advertisement.
about.
There are
Singapore,
always,
that's
So
what.
your
therefore,
brother is
vacancies,
telling
as the
that
Chief
the
Justice.
exam was
Later on it happened, four came about.
There are always, see, my brother is telling that
Later on,
the
2019
exam
and
was
2021.
and thereafter.
So therefore,
That is where I got this interim order in my favor.
So therefore,
Later on, 2019
this
and 2021.
exam, this advertisement.
That is where I got this
2015
interim order in
did
my
not
favor.
culminate. So therefore,
it got cancelled in
this
between.
Exam, this
No, 2013 never got
advertisement of
cancelled.
2013
The subsequent
did not
examination got
culminate.
cancelled.
So it got
It was not
cancelled in
2013.
between.
13 went through no, 2013 never got cancelled. Being
The
subsequent
subsequent
examination me out, and then my RTI, 13 went through his usual course of
Okay.
being eligible, knocking me out, and then my RTI lament.
The great biggest
We
concern is
kept on trying to get the matter listed. It was 20. I can lament, my lord.
So, the great biggest concern is, Mr. Mukherjee, the time that
It was 20.
was like this, when we have understood that we have kept the matter pending here, but then what do we do at this stage?
In fact, one of the difference of
We've
opinion
understood
with
that
my,
we have kept the matter pending
how I have
here,
understood the
but
two
then what do we
judgments.
do at this stage?
In fact, one of the difference of opinion by Justice Bhanumanti say a reference is pending. Understood the two judgments. Chief Justice Singh says it does not matter. That reference does not affect the facts of these cases. A reference is pending. Those three issues which are raised and answered says it does not matter. That reference does not affect the facts of these cases. So therefore, those three issues which are raised and answered are summarized here. The suffering continued with the full court resolution, knocking me out at the first stage, not including my name. The suffering continued with having a difference of opinion. Full court resolution, knocking me out at the first stage, not including my name. Then the Supreme Court having a difference of opinion. And I'm.
What is to be done according to you here?
Just one interjection. Very.
Yes.
What
is to be done according to you here? Rana says,
Just one interjection.
Mukherjee says that Here, Mr. First you told Rana says that Rana Mukherjee not qualified.
He is not qualified, my lord. I will show to your lordship. My
Then he
learned
gives
says
an
in the
RTI.
law.
First you told, after the RTI, you tell him you are qualified.
He is not qualified,
Then you
my
call
lord. I
a
will show
full
to your
court and
lordship. My
change the
learned
resolution.
says that is what I'm saying.
Finally, you tell him
No,
after
that's
the
what
RTI,
I'm
you tell him you are qualified.
No, 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 not
Then you call a full court and change the resolution.
law. That's what I'm saying.
Finally, you tell him that now you are not qualified.
You don't
get
in law,
qualified.
he is not qualified.
The advertisement was for an unreserved post. For unreserved post, minimum qualifying marks to appear in the advertisement was for an unreserved post.
He gets 52% in
Unreserved
return.
post, minimum qualifying marks.
Then he
to
made a
appear in the
representation to
Viva,
the High
my lord,
Court.
is 60%.
Yes, my lord.
He
He
gets
gets
52%
52% in return.
First, my lord.
Then he made a representation to the High Court.
Where do you get that?
Yes, my lord. Would your lordship
Of the
see the
PDF.
advertisement?
First, my lord.
Right.
The advertisement is at page 111.
Of the
Page,
PDF.
what is the page of the advertisement?
No, for first thing, my lord, I'm saying the advertisement, lordship would see page
What is
111,
the
which is PDF 111. No, for first thing, my lord,
Number
I'm
of
saying
posts
the
advertised
advertisement,
unreserved
lordship would see page
Yeah,
111,
we got it.
which is
And
PDF
now the
lordship may
111.
kindly see the rules. The
Number
entire
of
rules
posts
are, my lord,
advertised
at
unreserved.
397. One.
Yeah, we got it. Tell us.
And now the lordship may kindly see the rules. The entire rules are, my lord, at
Tell us that
397.
page where that 60 for that mark.
yes, my lord,
Tell us that
one-
page where you want us to go.
My lord, first triple one,
Just
my
tell
lord.
us that
One,
page
one,
where
one.
that 60 for that mark.
Yes, my lord, one, that is the advertisement, my lord. My lord,
First
which will
triple
show
one, my lord.
15th May
One, one, one.
2013, one vacancy, that is the
Particulars
advertisement at the bottom of the page, which will show 15th May
Unreserved
2013,
vacant post. This
one
unreserved
vacancy.
post.
Now, my lord,
Particulars
lordship may
at the
kindly see
bottom
the
of the
rules
page,
now, which is 397,
Unreserved
the entire
one
rules, my
vacant
lord.
post.
This is unreserved. Now, my lord,
Part of
lordship may
it.
kindly see the rules
The
now,
rule says,
which is
my lord,
397, the entire rules, my lord. My learned friend quoted from
page
some rules.
397
397 it starts. The rule
At
says, my lord,
401,
page 397 it
For
starts.
25%
Direct,
direct,
it should be as per
401.
schedule B. For 25% direct, it should be as per schedule B.
What is there? It says grade 1.
Yes, my lord, grade one, that is, my lord, that is 25% direct recruitment, page 401
What is
top.
there? It says grade 1.
Grade one. Yes, my lord, grade one, that is, my
direct
lord, that is
recruitment. On the last
25%
column,
direct
lordship,
recruitment.
direct recruitment.
Page 401 25%
top.
of the post should be conducted
Grade one,
as
that is, my lord,
specified
direct
in
recruitment.
schedule
On
B
the
of
last
the
column,
rules.
lordship, get direct recruitment.
My lord, sir, what? 25% of the post should be
Middle,
conducted
my lord, third
as
column.
specified
Not
in
exceeding
schedule B of the
25%
rules.
the post in the cadre.
My lord, sir, what?
Yes.
May be filled by direct recruitment.
On
Middle,
the basis
my
of
lord, third
aggregate
column.
marks
Not
secured in the
exceeding
competitive
25% of the
examination
post
conducted
in
by High Court
cadre.
as specified in
May be
schedule
filled by
1 of the
direct
rules.
recruitment
On the basis of
Schedule B of
aggregate
the
marks
rules.
secured
Now,
in the
schedule B,
competitive
lordship,
examination
get it
conducted by High Court as
428.
specified in schedule 1 of the rules. Schedule B of the rules. Now, schedule B, lordship would get it, my lord, at 428.
Not able. Neela, approve?
That, 60%.
Not able. Neela, approve?
That, 60%. Lord, for direct recruitment, 428, my lords have got it.
401, right?
Yes, 401
Lord,
first.
yes,
For
I'm so
direct
sorry.
recruitment,
So be
428,
that
my lords
not
have got it.
exceeding, आपको मिला? 401, right?
Yes, 401 first.
401
Yes, I'm
says,
so sorry.
Not exceeding Be that 20,
Yes,
not
it's
exceeding.
part of rule
आपको मिला?
7 column.
401
Not
says,
exceeding
my lord,
25%
Not
post in the
exceeding
cadre
20%.
may be
Yes,
filled by
it's
direct
part of rule
recruitment
7
on the basis of
column.
the aggregate marks grade secured in the
When not exceeding
competitive
25%
examination
post in the
High Court
cadre may be
as
filled by
specified
direct
in
recruitment on the basis of
schedule
the
B
aggregate
of the
marks.
rules. Grade secured in the competitive examination conducted by the High Court as specified in schedule B of the rules.
So this is says this is only the quota for the direct recruitment.
No, my lord, yes. My lord, then
As
lordship
per-
has
as
go
per
to schedule B.
As per schedule.
this is-
B.
Yes,
This
now
is
lordship
only
may
the
kindly
quota
see
for the
schedule
direct
B at
recruitment.
428. Yes, my lord, then
As
lordship
per-
has
as
go
per
to schedule
schedule,
B.
take us As to per schedule B. 428.
Yes, now lordship may kindly see schedule B at
Schedule B
428. Then lord, there are three papers.
Mr. Hansaria, take us to
Interview
428
50
direct.
marks.
Schedule
At
B
430, then lord, there are three papers.
Bottom.
Interview 50
All
marks.
candidates
At 430 who obtain 60% or more marks.
all
Or
candidates
corresponding grade value in the written examination shall be eligible for Viva post. Or more marks.
provided
Or
its
corresponding
schedule
grade
caste
value
schedule
in the
types
written
obtain
examination
50%
shall be
the corresponding
eligible for
grade
Viva
will be
post.
eligible for Viva post.
Look, this will
Provided
apply for
the
the
reserve
schedule caste
category.
schedule types
For the
who obtain
general
50%,
category,
the corresponding
C,
grade will be eligible for Viva post. Look, this will
Below
apply
general
for the
instruction.
reserve
It's
category.
general
For the
instructions.
general category,
C.
of part of schedule B.
Below general instructions.
This is general instructions, my lord.
Provided the schedule caste.
Of part of
schedule
schedule B, you have to get 60%.
50% marks or more.
For SC/ST, it will be, my lord, 50%. If you get 60%. But if it is SC/ST reserved seat, my lord.
Marks or more.
For SC/ST, it will be, my lord, are not reserved seat. But if it is SC/ST reserved seat, my lord, you have.
Cutoff is 60%.
Since the seat was, my lord, are not reserved seat, 50%, he gave a representation. You have, it was a new High Court in 2016, constituted. For the first time, 52%. He gave a representation. All like there are no available new High Court. In fact, that principle somebody could have challenged for the first time, saying that he's calling off considered all like there are no available candidates. For the High Court, I can't say that decision is wrong. Challenged it and saying that he's calling off interviews bad. Yes. Applying for the High Court, I can't say that decision is wrong.
For an unreserved seat.
Yes, my lord.
Mr. Hansari, you may not be correct.
Yes.
Reserved category candidate may
Yes,
also
my lord.
contest for an unreserved seat.
Yes, my
The
lord.
whole thing. Now,
Yes,
all
my lord.
candidates who obtain 60% or more marks for corresponding grade
Yes,
scheduled in the written examination. Let's see the whole thing.
Yes,
All
my lord.
candidates who
Please,
obtain
Lord.
60% or more marks for corresponding grade in the written
Yes.
examination shall be eligible for Viva Voce. Corresponding grade in the written examination scheduled tribe candidate eligible for the Viva Voce. 50% or more marks for corresponding grade.
My lord, I understand. What I'm saying, it is a possibility. My lord, I understand. What I'm saying,
School college admission happens like that.
my lord, it is a possibility.
Not for school college admission, my lord. School college admission happens like that. Yeah, for any post.
It is
Yes, that's not for reserve post. For reserve post,
For any post.
criteria.
For any post.
to
Yeah,
the
for any
candidate.
post.
It is
Not in the post.
the
It is
concessional
post, my
mark.
lord. That is, my lord, what
Is
very,
applicable
my lord,
to the
High Court having
candidate,
called him, my lord, I
Not in the
cannot.
post.
My lord,
Says you are
it
eligible
is
to appear
post,
for
that's
the
what
post.
he
You
made a
don't want to
repre-
argue
very
that you are not
good.
eligible.
High Court having called him, my lord, I cannot
High
kindly
Court
see
says you are
thereafter, my lord. After that, in the same page
He was
431.
eligible to appear for the Viva Voce.
I'm so sorry, my
He
lord.
was eligible to
Very
appear.
well, Lord, that he has been made a pillar. What I'm saying is 431 at the fourth, all necessary steps provided rules under this shall be decided by the recruitment committee. Thereafter, my lord, what is important is this: the mode of evaluation, page 431. After that quotation rule, all necessary steps not provided in these rules. So, my lord, it is silent. It is does not similarly required. For the recruitment, it shall be decided by, then thereafter, my lord, the mode of evaluating the performance of the grading in the written and Viva shall be specified below. So, my lord, both has been given. Grading and, my lord, for both written and Viva is below. Now, below is, my lord, the chart is there at page 432. So this chart is applicable for both written and Viva. Now, in says percentage of marks, O is outstanding. Well, this gradation, my lord, is not only in these High Court rules. For example, my lord, I have been checking on the line, National Institute of Technology. It also, my lord, here it does not say O is outstanding. A plus A, B plus B, C plus C, and F. F is in fail. It is written, my lord, in others.
That case where after the subsequent resolution,
Yes.
you prescribed a cutoff for Viva Voce. And in that Viva Voce, he according to you obtained 18 marks.
18.8.
18.8 as against the 40 required.
My lord.
That's the reason why you.
My lord, what I am saying, my lord, this.
Therefore, all other points that
No,
you
no.
are making.
Full
which
court
have
has
no relevance
interpreted
for-
these rules, my lord, and made it clarified. I'm saying it is not introduced for the first time. It is a clarification in nature. If your lordship see the full court resolution. Full court resolution quotes these rules, my lord, and also, my lord, the earlier part, and say, my lord, we will go by 40%. And can I not, my lord, an appointing authority?
Where is the requirement of 40% in the rules?
No, my lord, that's what I'm saying, my lord. Below 40%,
Where?
is this chart, page 432, which is, my lord, necessary for evaluation for both written and Viva.
Read that, please.
My lord, 431 bottom, it says mode of evaluation of performance of candidates for both in written and Viva shall be as specified below. My lords have got it, my lord. 431.
Okay, but this is the
Mode of
okay,
evaluating.
now go ahead.
I'm so sorry.
Go ahead. So
Yes, evaluating performance in the competitive exams for judicial selection. System operates as follows: all question paper carry numerical, etc., etc. Then the tabular will then convert the numerical marks into grades. 7-point grade corresponding as value follows. Then, my lord, these grades are given 70%, etc. You get so and so. My lord, if you got below 40%, it is F.
that 40% is not confined to Viva Voce.
My lord, it is written. My lord, it is the same standard. My lord, what the rule says, it is the same standard for written and Viva. That is 431. That's why I was reading 431. The mode of evaluating the performance.
It's merely saying because there was no prescription of having viva voce to be evaluated separately.
That's
Because
right.
there was no cutoff at that point of time. These rules relate to that period. So they say that anybody who obtains
Less than 40.
outstanding 70%, he will
Yes.
get grade 7.
Yes.
And anybody in a totality of the marks gets below 40%, he will be a F candidate and the grade is 0.
And F
To say, what has this got to do with your?
No, what I'm saying, my lord, before that, if I'm sorry, I've not made clear. 431 says, this tabulation, my lord, relate the mode of evaluating performance of grading in the written and viva
Yes, it's end viva. It has
shall be as specified below. So, my lord, this tabulation or mode of evaluation of gradation system,
He's saying, is it your argument saying that you first of all take the written examination and then see whether 40% is prescribed, whether he is falling under this category, then he will be eligible, then also have a look at the viva voce also.
yes,
And then the 40% has to be seen even for
both.
viva voce separately.
Also, yes, and that is how, my lord, the full court understood.
That was the way, that's the way you should read the rule. Then your
No, my lord, that's
full
why,
court was unnecessary.
then, my lord, we changed the rule because this
Then
proceedings.
why did you call for a full court then?
No, that's what let me explain that, my lord. Then, my lord, in full court took that decision, my lord. It is more of a clarificatory nature. In any event, before this, my lord, the interview was held by the full court.
And this scheme which you are showing commencing at Schedule B
Yes,
existed in the rules from the very beginning.
I'm so sorry, my lord. Yes, it's 2005 rules, my lord. The new High Court comes in 2013, Manipur High Court. And 2015, before the interview.
And you know, one more thing,
Yes,
this conversion, the rules prescribe, see, it's for each question.
my lord.
It's not for the overall exam. See how it is. Let's go back to internal page
Numerical
39, that is 431. The mode of evaluating the performance of grading in the written and viva voce examination shall be as specified below.
Yes, my lord.
Now, the system operates as follows.
Yes,
The questions in the question paper may carry numerical marks for each question.
my lord.
Okay. Now, the examiner may assign numerical marks for each sub-question which may be totaled up and shown against each full question in numbers. Now, the tabulator will then convert the numerical marks into grades in a 7-point scale with corresponding grade values as follows, which you showed us.
Please, lordship.
After converting the numerical marks of each question into the appropriate grade,
My lord.
according to the formula given in first column above, the tabulator will reconvert to the grades obtained for each question to the grade value according to the value given in the third column above.
My lord.
What is now obtained in the relevant grade value for each answer in the question paper obtained by the candidate in a 7-point scale. The tabulator's next task is to add up those grade values and divide the sum total by number of questions in the answer book, including the question unanswered by the candidate.
My lord.
Applying it to viva voce is a far cry, Mr.
Not on this analogy at least.
And it looks about, it refers to the answer book.
It goes on till clause 10. Then the viva comes in, cumulative score. I don't know what Mr. friend is trying to argue.
The similar vigorous and objective grade value exercise for the viva voce
The next
examination
stage,
as well.
yes. After the evaluation is done, after the question papers are evaluated and grades, because I would not get a look in if I had not got 52%. So these grades enable a candidate to get in a step in for the next stage. That's the viva. So 60, 50. I get the threshold of 50 plus. I get a call in for the viva. The viva comes in the clause 9. The final selection list will be ready by combining
two submissions, my lord.
and the viva voce. Clause 9.
First is, my lord. The
Say schedule to the rule, I say. Competitive examination, schedule B, it's a part of the rule. And then look at the way it is composed. It is putting questions and it is answering questions.
Yes.
See, look at this. Para 6. What happens if there are several successful candidates obtain the
Lord,
same
in
grade?
fact, Lord, these were Assam rules, my lord. These were lifted bodily from the Manipur. It is made for all the states, my lord.
Of course, the
I've checked up. The Assam rules are all identical, my lord.
And 9 is cumulative value of both.
My lord, what I'm saying is, my lord, apart from this, my lord, before he is, my lord, interviewed, the full court, which is the three honorable judges, my lord, who were there, who found that he was not, then he was called. Before this selection, the
follow
is that all this happened in 2013.
15.
13 advertisement, my lord.
16.
Right.
Let us take it
Now
to
we are
16.
10 years down the line, or at the least 8 years down the line.
No, I am told.
We'll
I'm
leave
told
it at that, Mr. Mukherjee.
No, may I say this first? I believe.
We can't spend more time in a
No, I understand.
constitutional bench in a matter like this.
No, I'll tell you,
Let's
Lordship.
close it by saying that, the selection relates to the year 2013. Selection process took place in 2015. At this stage, it is not possible to get you
So
appointed
the
as a...
question of the full, this reference would remain, my reference. No, I'm not talking of Tej Prakash. The reference in this, the
It's
division
not
of
necessary
opinion.
to answer the reference in this case.
Reference will answer in that matter.
No, that my submission is Tej Prakash is not attracted to my case. That's what I said at the beginning. Because of the difference of opinion, the issue will still be at large. Because if I follow Naushad, my lords,
On the facts, we don't have to answer this now.
Like at the very beginning, you have distanced yourself from the Tej Prakash.
yes, because
Distance, you said that I'll make submissions at the.
that's right. So that's what I was trying to submit that.
But on this.
My issues are different here.
Because of, for resolution of.
I believe 2 posts are filled up by retired judges. May I take the interim order to my advantage? I'll just pick two submissions. Just one minute, sir. Two submissions.
It is not a case, my lord, where anybody who is got lesser marks than him has been appointed. And at page 431, my lord, I'm so sorry.
Mr. Mukherjee, also there's the issue of the reference doesn't arise in this case.
The Tej Prakash issue does not. The reference in my case arises. The difference of opinion.
That is
Ah,
because of difference of opinion.
Before 3.
Yeah, that should go. Now just two submissions, because on this, what your lordship said, I believe because of this interim order, the last 2 posts are filled up by retired judges and they are appointed 2 years in rotation. I would still have 14 years of service, Manoj. He's willing to, by instructions, he's willing to join. Manipur, lordship sees 2 exams are cancelled, you don't get candidates. Here's a candidate who qualified. Why should he be knocked out like this? The High Court has been obstructing, even here, he's obstructing me, even from arguing.
Oh.
So I don't know why should the High Court start.
I'll sit down. I will stand up when my
Not how the 14 hours don't work.
Mukherjee, what we were wondering is that, really speaking, there's a difference of opinion between 2 judges
On rule.
on the application of the rule,
On that, yes, the interim.
right? Now, in that case, it has to be resolved by a bench of 3.
Yes.
If the issue which has been referred to the Constitution bench does not squarely arise over here, why should we entertain it? We'll send it back to a bench of 3 judges.
And also equities can be looked into by that bench and then say because one.
Could I make a soft request, Manas?
Yes.
Subject to your lordship's convenience. Could this be listed as fast as
Yes,
possible,
yes.
Manas? Because
We can.
every day I'm
We can,
losing
we can,
time.
we can.
Every day I'm losing time.
Sure, just-
The proceedings have been on, on 7 October 2016. The bench of two learned judges, which was considering writ petition civil 294 of 2015, deferred. Full stop. Now, when was it tagged?
Then it just said
August 2017, my lord.
Right, I got it. Thereafter, on 10 August 2017, a three-judge bench passed the following order. वो copy कर लीजिए. So, from the above narration, it emerges that the direction to tag the matter with the reference to the Constitution bench in Tej Prakash Pathak versus Rajasthan High Court 2013 for SEC 540 was on the submission of learned counsel appearing on behalf of the contesting parties that a similar question of law had been referred. But during the course of the hearing, Mr. Rana Mukherjee, learned senior counsel appearing on behalf of the petitioners, submits that
these questions arise for. That we had variance with the Tej Prakash reference, so it will be easier for me to argue there. But we can't have this. I'm sorry. Fine. I'll give you a copy. How many have it? Yeah.
No, there are other questions.
Mr. Rana Mukherjee, learned senior counsel,
No, there are other questions.
appearing on behalf of the petitioner, submits that submits that the following three questions would be sought to be urged in the course of the decision of the reference to the three judges, to the three-judge bench, ये 1, 2, and 3 copy कर लीजिए.
Just a procedural.
Yes. Procedural fairness and fairness.
No, there are other questions which also arise. Otherwise, Lord, I will be foreclosed from arguing.
Mr. Vijay Hansaria, learned senior counsel appearing on behalf of the respondent, states that he would wish to raise certain other questions.
Lord, which I have raised, Lord, in my submission.
Yes,
We are keeping it open.
Since in view of the statement which has been, since in view of the above position, it emerges during the course of the hearing that a reference to the Constitution bench along the lines as in Tej Prakash Pathak is unnecessary. But stop. The difference of opinion between the two-judge bench between the two judges would have to be resolved by a three-judge bench. Stop. We accordingly direct the registry to add the present case to the list of three-judge bench matters and to seek an assignment to an appropriate bench at
slightly higher
at an early date.
Because there's an earlier order of
At an early date, I'll take it. I have to assign that. I'll take the
I
registrar.
understand, madam. The pressures are.
No, I'll immediately do that.
I'm deeply obliged, madam.
Yes. Yeah, we'll have to decide that Tej Prakash in that matter.
I'm deeply
Easier with